Viewers, welcome to the Personal Injury Law Show. My name's Tony Carbone, lawyer of 25 years experience in personal injuries. Next to me, I've got an up-and-coming superstar in the law, Nuncio Tartaglia.
Tony, good evening. Alice?
Do a lot of public liability work, Nuncio.
Yeah, that's my specialty.
And Alice O'Kane, sensational young up-and-coming lawyer.
How are you going?
Welcome aboard tonight, Alice.
Thank you.
Tony, what's in the news this week?
Well, there's been a lot in the news, but the story I want to highlight, because we're talking about air carriers liability, that is aircraft accidents and the like, I want to talk about this stunt pilot that rams into an airshow crowd. A 74-year-old fellow flying one of these old Mustangs, and he's nosedived into a crowd and killed a lot of people and maimed and injured quite a few others. Just curiously, if this happened in Australia, what would be the rights of the people that were injured and killed in this accident?
Well, if this happened in Australia, Tony, it would fall under what's called the Damage by Aircraft Act, which has been introduced for damage or bodily injury to a third party. So there is some protection afforded to third parties in Australia if this did occur, which is, thankful, because, that's nasty, Tony.
And is there any prerequisites to the people claiming, Alice?
They'll have to demonstrate what injuries they've received, and it will also depend upon the circumstances of each case, obviously, Tony. But
in terms of the actual accident itself, just the fact that it's an accident qualifies them?
That's right. Just the fact that it's an accident qualifies the people.
You just need to show that there's some sort of, damage caused by the impact of the plane, and in this case, it's
very
prevalent.
clear.
So.
Yeah.
It's got to be caused by not the person claiming.
That's right.
That's it.
Yeah.
That's right.
Okay, just on that issue there, Alice, what's the state of the law in relation to air carriers liability at the moment?
Generally speaking, Tony, air carriers liability for accidents that occur on planes is covered by the Civil Aviation Air Carriers Liability Act, and it incorporates several different concepts from both the Montreal Convention and the Warsaw Convention. Obviously, because a lot of accidents that happen on a plane happen over the water in terms of an international flight, and so there's several different international conventions that apply depending upon the circumstances.
But the various countries adopt the Warsaw Convention and Montreal Convention, don't they, Nuts?
Yes, they do, and look, I think they're all leading more toward the Montreal now, and I think under the Montreal Convention, I think there's 91 countries that are signatories to that convention, and Australia is one of those, United States.
What's the main difference? Why is there this shift?
There's a bit of a shift, Tony, because the old Warsaw Convention is quite lengthy, it's quite complex, and the Montreal Convention came into effect in Australia in January 2009. It's slowly replacing a lot of the law that was brought up by the Warsaw Convention, but it's simplifying it somewhat and making it a little easier for everyone to deal with.
But the entitlements of injured parties has been capped under these two conventions.
That's right. That's right. Look, Tony, it'll depend, generally speaking, upon the circumstances of the case, but in most cases, the entitlement to damages is capped. It's set at approximately 290,000 Australian dollars, although in very special circumstances, you can break that cap.
Okay, we'll get to those later on because there's a couple of cases we want to have a look at.
That's right.
Just curiously, why don't we go to the first case that we want to talk about, and that is Povey and Qantas. Now, this is famous because this is a DVT case. This was really a test case, wasn't it, Nuns?
Yeah, it was, and look, it's now, I suppose, the law with regard to DVT, that occurs on a plane.
Do you want to give us the facts?
Look, basically, this gentleman, I think it was flying from Sydney to London on an international flight with, I think it was British Airways at the time. The case was against Qantas, but they're owned, I think, the same signatories. And he suffered deep vein thrombosis on the plane, and obviously took action against Qantas according to I think it was the Warsaw Convention at this time, and said that it was an accident under the Warsaw Convention Act, and that's what needs to be proven.
Now, what the Povey had to prove is that the carrier is liable for damage sustained in the event of a death or wounding of a passenger or any other bodily injuries suffered by a passenger. If the accident, now the key word is accident.
That's right.
If the accident is caused, the damage so sustained took place on board the aircraft or in the course of any of your operations of embarking or disembarking. What happened in Povey, Alice?
Tony, he didn't succeed at the end. The case went through several courts, and the courts are very, very concerned with this concept of accident, and it's been refined and reformed over the years since Povey. But the general idea is that an accident needs to be something that's external to the passenger. So a bit like what we were talking about before, it can't be something caused by the passenger. It needs to be something you can attribute to either the airline or external circumstances within what happened to you. And the difficulty with Mr. Povey, he alleged, for example, that the seating was too cramped and that the aircraft really didn't it really didn't provide for a safe travel.
Discouraged movement as well.
That's right, but he really didn't succeed because of the nature of his condition.
There's been a lot of changes since then. A lot of the airlines do encourage people to get up and move around the plane.
Look, they do. Look, this is a case where he's also alleged that the airline failed to warn him with regard to the risks of getting DVT on a plane, and the court found that, look, this wasn't, I suppose, enough to get him over the line. But I think the airlines have taken on board, and they start now giving you warnings about that. So
look, the reality is that it was a policy decision. If Povey had got up, Alice, there would have been thousands of claims.
That's right, and it's more of a regulation thing too as well, Tony, because at the end of the day, it does open the floodgates a bit, especially with something like deep vein thrombosis, which is a really unpredictable condition.
And just on the issue of airlines, one of my sons is doing aviation, and he says that they've got a very low margin of profit. It's only about 5%. So I'd imagine that the courts were thinking if they start paying out all these people, there won't be, they'll go out of business. That's probably a big consideration.
Their premiums would just go through the roof, and I don't think they could substantiate.
They're probably self-insured, aren't they?
That's right.
Oh, they would, but it almost put a big hole in their pocket.
It would make it very difficult.
So isn't the key element of this, it's got to be an accident?
That's right, Tony. And it has to be an accident that's external to the actions of the passenger. So the airlines really do modify it, or the courts really do modify it down, and they're really concerned with the circumstances. They'll pick through them very carefully before deciding whether or not it's an accident.
The way they've worded, I think it's got to be unexpected, unusual, or outside the happening, external to the actual plaintiff or the the injured person. So it's got to be outside their control, and that's what's defined as an accident.
Look, I wanted to get onto this other case, and I know we've got to go to a break shortly, but under the Warsaw Convention, and Part 4 in particular, which has been embraced by our legislation, what are the limits of liability, Nonce, do you know?
Well, under the Warsaw Convention, you're capped at about $290,000. Under the Montreal Convention, I believe it's around $200,000. Now, these can be extended upon if I think you can prove that the airline had knowledge of, I suppose, an injury or a danger that was posed. So they can be increased. With regard to the Civil Aviation Carriers Liability Act in Australia, that's capped at 500 tons.
Okay.
And you can't go beyond that, doesn't matter how far you go.
There are exclusions, which we'll talk about later on.
Yeah, we'll get to that.
Alice, of significance, if you can prove an accident, liability strict.
That's right, Tony. That's right, which means if you can prove that the circumstances which caused your injury or an accident, then that's as far as you need to go. The court will then accept that it's the airline's fault, what happened to you, and then they will turn their minds to awarding compensation.
Look, we're going to have to go to a sponsors break, guys, so we'll tell the viewers to stay tuned and don't go away. We'll be back shortly, and after the break, we'll talk about the case of Braddock. Thank you, viewers.